a root problem. He doesn't make any argument that anything in the deposition is sensitive or private in nature. In other words, he doesn't really make any real arguments as to why this entire deposition should be treated as confidential.
CoffeeZilla is not a criminal. I called him, I apologized.
So there's a fresh update in the Logan Paul defamation lawsuit against CoffeeZilla, and the situation is getting messy in a whole new way. It really looks like Logan and his legal team are trying to spin the narrative in court and convince the judge of something that just doesn't add up. If you haven't been tracking this case closely, things are not moving in Logan's favor. Over the past few weeks, he and his attorneys have been pushing hard to keep his deposition hidden from the public, and that move alone has people raising eyebrows. For anyone confused about what a deposition is, let's break it down simple. In this case, it's CoffeeZilla's lawyers sitting across from Logan, asking direct questions under oath about the crypto projects and business moves that sparked all this drama. It's serious, it's recorded, and it can be used in court. So naturally, people are wondering why Logan is fighting so hard to keep that footage sealed. The obvious guess is that the questioning didn't go his way. Word around the case is that CoffeeZilla's team pressed him in ways that may not reflect well on him publicly. Now here's the key point. Does Logan actually have the right to hide his deposition just because he doesn't like how it makes him look? Not really. Depositions are a normal part of legal proceedings. Unless there's sensitive private information involved, courts usually lean toward transparency. But Logan's team is still trying to argue that it needs to stay confidential, claiming they're protecting the integrity of the case. As always, credit goes to Legal Bites for breaking down the legal filings and explaining what's happening step by step. According to the latest update, Logan presented 4 reasons for wanting the deposition sealed. The first argument was that CoffeeZilla supposedly can't be trusted with it. His legal team claimed that if the deposition isn't sealed, CoffeeZilla might release it publicly, share it with other attorneys, or even pass it along to investigators. The problem is, none of that is against the law. If someone legally obtains information during litigation, sharing it with proper authorities isn't some shocking violation. The second argument Logan made was that CoffeeZilla has allegedly been sharing case information with the FBI. Because of that, he says the deposition should stay confidential. But here's where that logic falls apart. There's no rule that says you can't provide lawfully obtained evidence to law enforcement. That's not misconduct. That's actually how investigations often move forward. So at this point, instead of calming the situation down, these arguments are just adding more attention to the case and making the whole strategy look questionable. Enforcement is where Logan's third argument comes in, and this one is just as shaky.
So here we're talking about how I think that in Logan Paul's reply, his lawyers did some things that can potentially backfire. And explaining this really starts with the weakness of his arguments. Let me put it this way. There's this old trial lawyer's saying that if you're weak on the facts but strong on the law, pound the law. If you're weak on the law but strong on the facts, pound the facts. And if you're weak on both, pound the table. Pounding the table is often thought of as being like forceful or aggressive in your tactics. But I actually like to think of it as any strategy to try to essentially distract from the fact that there really isn't much to your case or your position in this particular argument. But the thing is, depending on your strategy here, you could find yourself in the danger zone with the judge. And I think that is where we just might be in this particular issue. To start, Logan Paul's reply is an opportunity to strengthen the arguments from his original motion. It's supposed to be pretty limited in that it's supposed to be responding to the opposition, but nevertheless, it should be able to use something to kind of bolster it somewhat. But instead of doing that, he basically repeats all of the arguments from his original motion, all of which, like I said, I think are already pretty weak. Now, to make matters worse for Paul, his lawyers at one point in this reply tried to do that thing that I described earlier. You know, where both sides will take the legal authority that the other side is using to support their arguments and try to show how it actually supports our side. But the problem is, as much as Paul's lawyers are trying to do that, in my opinion, I think they're very unsuccessful at it. For example, in this part of the reply, they're responding to CoffeeZilla's argument that in order to mark his deposition as confidential, Paul needs to show good cause. And this basically means that Logan Paul needs to have a good, rational reason that has something to do with some kind of privacy interest. It's really not all that hard to do, but the problem for Logan Paul is that nowhere in any of these filings does he ever argue that he has good cause for making any part of his deposition confidential, let alone the whole thing.
He tried to claim there's already a protective order in place, and that CoffeeZilla is somehow violating the spirit of that order by sharing information outside the lawsuit. The issue with that claim is simple. The protective order doesn't actually block CoffeeZilla from sharing non-confidential material. It only applies to specific protected documents. So saying someone broke the spirit of an order that doesn't even cover the material in question feels like a stretch. Then Logan's fourth point was about CoffeeZilla allegedly sharing information with attorneys involved in the CryptoZoo class action lawsuit. He framed that as improper, like something shady was going on behind the scenes. But CoffeeZilla's legal team quickly shut that down. They made it clear that non-confidential discovery can absolutely be shared with lawyers in related cases. That's normal legal practice. There's nothing scandalous about coordinating when cases overlap. When you line up all four of Logan's arguments, it's hard to ignore the pattern. None of them really land. None of them point to an actual rule being broken. Everything he's complaining about falls within what the other side is legally allowed to do. That's why a lot of legal commentators are saying this isn't going the way Logan probably hoped. There's also been talk about a lot of dramatic back and forth in court filings, but as Legal Bites explained, Logan's team hasn't introduced any strong new facts to support sealing the deposition. Instead, these responses read more like attempts to stall and overwhelm the court with paperwork. The bigger picture here is that Logan is pushing hard to keep that deposition sealed, likely because the footage does not paint him in the best light. But legally speaking, his reasoning for hiding it just does not hold up. At this stage, it feels less like a strong legal defense, and more like a strategy to drag things out. Logan has the financial resources to keep filing motions and stretching the timeline. Meanwhile, the core issue remains untouched. The real question is whether his public statements and actions around CryptoZoo were misleading. Instead of confronting that head-on, the focus keeps shifting to side battles over documents and technicalities, and that says a lot about how this case is unfolding. For the past few weeks, Logan and CoffeeZilla have basically been going back and forth through court filings over side issues. Should the deposition be sealed? Can discovery be shared? Did someone violate the so-called spirit of a protective order? None of these arguments actually answer the main question at the center of this lawsuit, but what they do accomplish is stretching the timeline and driving up legal costs. And that kind of delay can benefit someone with deeper pockets.
Instead, Paul tries to suggest that the case law CoffeeZilla is citing to says it's actually a more lenient standard than what CoffeeZilla is arguing. Specifically, Paul says defendants' own authorities recognize that the standard for designating non-filed materials as confidential is, quote-unquote, more lenient. And then Paul cites to this case from the Fifth Circuit, Hoa Lee v. Exeter Financial Corporation. But the thing is, although Paul says that there's like this more lenient standard, he doesn't exactly say what that more lenient standard actually is. And there's a very good reason for that. That's because if he did, it would naturally highlight the fact that the one thing that the Fifth Circuit says that Logan Paul needs in order to mark the deposition as confidential is good cause. Specifically, here's exactly what the Fifth Circuit says. In our view, courts should be ungenerous with their discretion to seal judicial records, which plays out in two legal standards relevant here. The first standard, requiring only good cause, applies to protective orders sealing documents produced in discovery. And then it goes on and actually says, under both standards, the working presumption is that judicial records should not be sealed. So reading that, the Fifth Circuit is actually pretty clear that Logan Paul's motion should absolutely fail.
Every new motion forces CoffeeZilla's legal team to respond. That means more billable hours, more preparation, and more money spent just to keep up. It becomes a battle of endurance. And in cases involving wealthy public figures, courts see this tactic all the time. Long procedural fights can sometimes pressure the other side financially. But here's the twist. When someone is truly confident that their deposition clears their name, they usually do not fight this hard to keep it hidden. Pushing aggressively to seal it can create the opposite effect and raise even more suspicion. Dragging the case out might buy Logan time, but it also sends a message. It makes people question whether the actual facts support him. In civil lawsuits, sealing records is not easy. The legal standard is high. Judges do not block public access just because one side claims it could look bad. There has to be a clear, specific, and evidence-based reason. Typically, courts only grant sealing when the material contains truly sensitive information, like detailed private medical records, personal financial account numbers, or protected information involving a minor. Even in those situations, judges prefer narrow redactions. That means blocking out a specific sentence, a name, or a small portion of a page, not hiding the entire document from view. And that's where Logan's request runs into trouble. You cannot just seal a whole deposition because it might be embarrassing or because it could be used against you in public debate. The court usually requires exact page numbers, exact lines, and a precise explanation for why each part qualifies as confidential under the law. Simply saying this could hurt my image is not a strong legal argument. It sounds more like damage control than a legitimate basis for secrecy. And that argument of please don't make it public just does not fly in a courtroom. In civil cases, transparency is the default. Courts are designed to serve the public, not protect the image of wealthy defendants. The public has a right to see how justice plays out unless there is a clear and serious reason to limit access. That's the foundation of the system. What makes this even more surprising is the case Logan's team decided to cite in their defense. They pointed to a past ruling to argue that the judge should be more lenient when it comes to sealing records. But when you actually read the language from the Fifth Circuit, it does not really help them. The appeals court explained that one standard, requiring good cause, applies to protective orders during discovery. But once a document is filed on the public record and becomes part of the judicial record, a stricter balancing test applies. And here's the key part. Under both standards, the presumption is that judicial records should not be sealed. That is the starting point. That means Logan cannot just say, this is inconvenient or this could hurt my reputation. He has to show real, specific good cause backed by evidence. Without that, the deposition stays public. That is how the system is built to function. It is hard not to notice that the very authority Logan's team cited seems to support CoffeeZilla's position more than their own. The ruling reinforces the idea that transparency comes first. Secrecy is the exception, not the rule.
And by the way, not only is this understanding of this issue pretty common across the board in the United States, but the Fifth Circuit is also binding authority on the court that we're in right now with this lawsuit. In other words, the judge in this case is required to follow this case law. And I want to share a little bit more from this Fifth Circuit opinion because I think it beautifully illustrates why it's important for the public, you and me, to have access to this kind of information. For context, this case, Hoali v. Exeter Financial Corporation, involved two parties who basically agreed behind closed doors to keep like 3/4 of the discovery in that case marked confidential, and then to seal it permanently just so that the public could never have access to it after the litigation was over. And by all appearances, they didn't do this because this information was actually sensitive in any way. It's just the parties wanted to keep information private amongst themselves. And so the Fifth Circuit said in response to this, the public deserves better. The presumption of openness is Law 101. The public's right of access to judicial records is a fundamental element of the rule of law. Openness is also Civics 101. The Constitution's first 3 words make clear that ultimate sovereignty is wielded not by the government, but by the governed. And because we, the people, are not meant to be bystanders, the default expectation is transparency, that what happens in the halls of government happens in public view. Americans cannot keep a watchful eye either in capitals or in courthouses if they are wearing blindfolds. Providing public access to judicial records is the duty and responsibility of the judicial branch. Why is this important? Because accessibility enhances legitimacy, the assurance that things are on the level. Article 3 courts are independent, and it is particularly because they are independent that the access presumption is so vital. It gives the federal judiciary a measure of accountability, in turn giving the public confidence in the administration of justice. Put simply, protecting the public's right of access is important to maintaining the integrity and legitimacy of an independent judicial branch. And hopefully, more access to judicial records means more trust in judicial officers and more respect for judicial orders. Judicial records belong to the American people. They are public, not private documents. Certainly, some cases involve sensitive information that, if disclosed, could endanger lives or threaten national security. But increasingly, courts are sealing documents in run-of-the-mill cases where parties simply prefer to keep things under wraps. And so this opinion goes on. If you want to read more from it, which I highly recommend, I am linking to a copy of it in the description below. It's very passionate and very clear about how we shouldn't just be allowing parties to mark something as confidential simply because they want to keep it out of the public's eye. And oddly enough, that sounds like exactly what Logan Paul is trying to do here.
Throughout this entire case, Logan still has not presented a concrete, legally sound reason for sealing the deposition. The arguments so far have not met the required standard. What also stands out is the scale of resources involved. Logan has the ability to hire experienced attorneys and spend significant money on litigation strategy. Yet the filings we have seen do not introduce new strong legal grounds for sealing. Instead, they repeat arguments that courts typically reject. That has led some observers to question whether this is about winning the sealing request at all or simply extending the process. At the end of the day, the principle is bigger than one influencer. Public court records exist for accountability. If judicial documents could be sealed anytime a powerful figure felt uncomfortable, transparency would become selective. The legal system is structured so that wealth and status do not automatically grant special privacy in civil disputes. That is exactly why the presumption favors openness in the first place. That is exactly what the Fifth Circuit warned about, and it connects directly to the CryptoZoo lawsuit and even the Pokemon Liquid marketplace situation that is now under investigation. These are not small private disagreements between two random individuals. We are talking about projects tied to millions of dollars, massive online audiences, and thousands of supporters who say they were financially impacted. When a public figure like Logan builds a business using his platform and loyal fanbase, and that business later collapses, it stops being just personal drama. It becomes a public issue. In the CryptoZoo situation alone, many buyers said they lost serious money after being told refunds and fixes were coming. Some claim those promises never fully materialized. That is why the deposition matters so much. The public wants to know whether what Logan said under oath matches what he told fans in apology videos, social media posts, and interviews. If there are contradictions between his sworn testimony and his public statements, that would raise major credibility questions. It is not hard to see why there is so much focus on keeping that deposition sealed. During questioning, CoffeeZilla's attorneys likely asked detailed questions about refund decisions, timelines, and internal communications. For example, why were certain investors refunded partially while others were not? Those are the kinds of specifics that can become uncomfortable under oath. If the answers were unclear or inconsistent, that could create problems beyond just this lawsuit.
Now that we see the weakness in Logan Paul's arguments here, I want to talk about the pounding on the table part. Specifically, here's where I want to talk about what Logan Paul's lawyers do that I think could end up backfiring. Now, there are actually a couple things that Logan Paul's lawyers do in this reply that the judge might not like, but I really want to focus on one of them. And basically, it looks to me like Paul's lawyers may have twisted the judge's words out of context in order to make their argument.
It's a bold strategy, Cotton. Let's see if it pays off for him.
Let me explain. So remember how in his motion, Logan Paul pointed to something that he says the judge said at some point. Specifically, Paul says, plaintiff has reason to believe that Mr. Findeisen and his counsel have routinely been sharing discovery materials from this case with the class action plaintiff's counsel, something this court expressed concern about when it decided to temporarily stay this case, and conduct which, again, constitutes use of discovery materials for purposes other than litigating the claims and defenses in this action. So now when you read this, it sounds like back when the judge decided to temporarily freeze this case back in September, he had this super serious concern specifically about CoffeeZilla sharing information with the class plaintiffs. But if you watched my first video on these arguments in this particular issue, you know that I looked back at the judge's September order staying the case, and I saw that the judge didn't say anything about this in that written order. And so in that video, I said, the only thing that I can really think of is maybe the judge made some kind of a comment at the hearing just before this written order came out. And as it turns out, in the reply, we finally get to see that that's in fact where Logan Paul's lawyers are getting the idea that the court expressed this concern about the sharing of information. Specifically, Paul's lawyers attach a very small bit of transcript from this hearing to show this. It's really not enough to get full context on what exactly was being said, but we can basically put together more or less the main gist of it. And the thing is, now that I've seen at least this much of what the judge said here, based on how much I can put together, it kind of looks like Paul's lawyers may have twisted some things here.
Legal Bites also pointed out something interesting about Logan's recent filings. She explained that his legal strategy may be backfiring. According to her breakdown, Logan's team seems to be reframing the judge's earlier comments to suggest that the court already had serious concerns about CoffeeZilla's conduct. But when you review the judge's written order from September, that supposed concern about discovery being shared with CryptoZoo class action attorneys is not clearly stated there. In other words, Logan's filing implies the judge was worried about something specific, yet the official record does not appear to reflect that same concern. That kind of mismatch can weaken credibility in court. Judges rely heavily on accurate representations of prior rulings. If a party appears to stretch or reinterpret the court's own language, it can hurt their position rather than strengthen it. The only way Logan's team tries to back up that claim is by attaching a very small excerpt from a hearing transcript, and even that clip is missing full context. It does not clearly show the judge criticizing CoffeeZilla or warning him about sharing information. When you read it carefully, it sounds more like a general courtroom discussion, not some dramatic reprimand. But in Logan's filing, that small snippet is presented like it proves something major. That is where things get risky. Courts expect attorneys to be extremely precise when quoting a judge. You cannot take a few lines out of context and stretch them into a sweeping concern that was never clearly expressed. If it looks like the court's words are being exaggerated or reframed to fit a narrative, that can damage credibility fast. Judges pay attention to how accurately lawyers describe prior rulings. Once credibility slips, it is hard to rebuild. From the judge's perspective, this may not look like a focused legal defense. Instead, it can start to resemble a wealthy litigant trying to push procedural angles rather than address the core issues. If the court begins to view Logan not as someone protecting legitimate confidential interests, but as someone mischaracterizing prior statements and consuming court time with weak arguments, that perception alone can influence how future motions are received. There is also an important detail that Legal Bytes highlighted. When you read the transcript in full context, the judge's concern does not appear to center on CoffeeZilla acting improperly. Instead, the discussion seemed focused on the overlap between two active cases. Logan is connected to both the defamation suit and the Crypto Zoo class action. The judge appeared concerned about how discovery in one case could potentially impact proceedings in the other, especially since the class action plaintiffs are not formal parties in the defamation case.
And if that's the case, that is a problem for them because that would mean that they are twisting the judge's words to the judge. Let's take a closer look so you can know what I mean. So this hearing transcript that Paul attaches starts out where the judge is talking about CoffeeZilla's earlier request to transfer the case from San Antonio to Austin so that it can be litigated in the same court as the class action case. And there's discussion leading up to this that we can't see, but he basically concludes that he doesn't want to transfer the case over there. So the judge says at the top of this page, "So I'm wondering, I will tell the parties the motion to withdraw, the transfer to withdraw. I'm not transferring this case to Judge Griffin. It would not be fair. I've already had involvement in this case, he's got enough on his plate. But I am considering staying some or all of the proceedings in this case while that case gets rolling. I need to hear from the parties on it. I'm concerned about it. Judicial resources need to be economized. There is the danger of prejudice to both sides. I'm very concerned, even though there's a voluntary agreement by these potential class members to subject themselves to deposition, I'm concerned that that could be prejudicial to them. I'm concerned with the team on the Logan Paul side that some of this information would be information that could be used in the other case, even with the protective order. And the flip side, of course, anything that was disclosed by defendants in this case to Mr. Paul, how could he not use that in that case? I'm worried. I do not want to prejudice the parties. I need to hear from the parties as to how to address these issues. It's separate from the motions in front of us. I'd like to start with the plaintiff." So it sounds like what the judge is really saying here is, we have these two cases where one person is a party in both of them, that's Logan Paul, and then you otherwise have other people who can be affected in one case by something in another case that they're not even involved in. And so rightly, the judge is worried that there are things that can happen here that could lead to an unfair prejudice to one or another side, and if these parties start to engage in discovery funny business.
CoffeeZilla is not a criminal. I called him. I apologize. Step 2, we want to offer a rewards program for players who are disappointed in the status of the game. So essentially, you're going to be able to burn your base egg or your base animal for the mint price, which was 0.1 ETH or the equivalent in BNB. I am personally committing 1,000 ETH to this, which is about $1.3 million. I'm sorry, guys. I apologize for how this has unfolded thus far. And I want people to know that they can trust me and that I'll always take care of the fans and people who support me. And lastly, thank you, CoffeeZilla. You have catalyzed this, and I am very grateful for your work and your investigation. And I mean that. Thank you, bro.
That distinction matters a lot. Logan's team has framed the situation as if the judge was alarmed by CoffeeZilla sharing discovery. but the broader context suggests the judge was thinking about procedural fairness between overlapping lawsuits. When courts are dealing with parallel litigation, they often want to ensure that one case does not unfairly influence another. That is a structural concern about case management, not a condemnation of one side's behavior. If the filings continue to blur that distinction, it could weaken Logan's position further. Judges rely on accurate characterizations of the record. When those characterizations do not align with the transcript itself, it raises questions about the strength of the underlying argument. That is a big reason why the judge refused to transfer the case to Texas and instead explored whether certain parts should be paused. From the court's perspective, the concern appeared to be about fairness. When two related lawsuits are moving at the same time, judges have to be careful that discovery in one case does not create an uneven playing field in the other. The goal is to prevent any party from gaining an improper strategic edge. Some critics argue that Logan is attempting to use the defamation case as a way to gather information that could later benefit him in the CryptoZoo class action. That accusation is serious. In complex civil litigation, discovery can reveal internal communications, financial records, and sworn testimony. If material from one case is positioned to influence another, courts have to manage that carefully to avoid prejudice against other parties. Logan's past public statements have also added to the scrutiny. After the CryptoZoo controversy gained attention, he released apology videos where he acknowledged criticism, thanked CoffeeZilla for highlighting issues, and promised that affected buyers would be refunded. At the time, that messaging suggested accountability. However, some participants later claimed that refund offers were conditional and required signing non-disclosure agreements, which limited what they could say publicly. Those details remain part of the broader debate surrounding the project. The earlier attempt to move the case to San Antonio also drew attention. Venue changes can sometimes offer strategic advantages, whether through jury pools or procedural factors.
And the reason this probably came up is because, remember, the judge started out here in this hearing transcript talking about CoffeeZilla's motion to transfer the case. If we look back, in that motion, CoffeeZilla made the argument that the whole reason Paul filed this lawsuit was to purposely engage in funny business. Specifically, one reason was to punish CoffeeZilla, and then the other was to get around roadblocks that came up in the class action case and to gather discovery from CoffeeZilla that he could use in the class action case and during a time when the class plaintiffs weren't able to collect any discovery against Paul. So with that in mind, when we look back at this hearing transcript that Logan Paul has attached to his reply, let's home in on one part specifically. The judge says, "I'm concerned with the team on the Logan Paul side that some of this information would be information that could be used in the other case, even with the protective order." What that means is the judge is actually recognizing that the protective order can't necessarily stop CoffeeZilla from sharing non-confidential information with the class plaintiffs. And then, importantly, the judge immediately also says, and the flip side, of course, anything that was disclosed by defendants in this case to Mr. Paul, how could he not use that in that case? Again, he's saying, how could he not use that in that case? That means he's once again acknowledging, I know I can't stop Logan Paul from using discovery over there after he gets it over here. And so what we can piece together is that the judge here isn't saying, hey, CoffeeZilla, you're not allowed to share information with the class plaintiffs at all. And to be clear, that is actually what Logan Paul is trying to suggest in this current argument over his deposition. But rather, what it sounds like the judge is actually saying here is, I'm worried about all of this just turning into a huge mess where both sides start to abuse the discovery process across the board to get an unfair one-up on each other between these two cases.
The judge ultimately declined that request. Observers have pointed out that Logan previously appeared comfortable with overlapping case dynamics when they potentially favored him. Now, in the defamation case, he is strongly objecting to the possibility that his deposition could circulate or be referenced in related proceedings. From a procedural standpoint, if discovery is lawfully obtained and not subject to a valid confidentiality restriction, it can often be shared with appropriate parties, including legal teams in related cases or investigators. That is part of how interconnected litigation functions. The tension here lies in how those rules are being applied and interpreted by each side. Viewed from the outside, the situation resembles a high-stakes strategy battle. CoffeeZilla's legal approach has focused on maintaining access to information and resisting broad ceiling requests. Logan's team, on the other hand, has concentrated on limiting how certain materials are distributed. In complex litigation, each move can influence the next. The outcome will likely depend less on dramatic claims and more on how the judge interprets procedural fairness, transparency standards, and the credibility of each side's filings. And this is exactly why the judge raised the issue in the first place. CoffeeZilla had already argued that Logan may have filed this defamation lawsuit for strategic reasons, possibly to work around discovery limits in the Crypto Zoo class action. The concern is not just about hurt feelings or online criticism. It is about whether this separate case could be used to access testimony, documents, and legal strategy that would otherwise be harder to obtain in the class action.
Importantly, then the judge also says, okay, attorneys on both sides, give me your thoughts about this. That is signaling that this is the beginning of a discussion with both sides. And unfortunately for us, Paul does not attach more transcript here to show how that conversation went, what the attorneys said on either side, or what the judge said at the end of it. So for our purposes, there's this really big question mark as to where the topic settled at the end of this hearing. But the reason I personally doubt that the judge ended up feeling just as concerned at the end of all of this is, again, he didn't say anything about this in his formal written order that followed up this hearing, and he totally could have if he had wanted to. If he was still concerned, he likely would have reminded the parties about that concern in that written order. However, although we can't be sure from this vantage point that you and I are sitting in, the judge obviously was there for the hearing, and he most likely remembers why he was concerned and what he said and how he felt at the end of this hearing. And in my experience, judges don't often take too kindly when they think that one party is taking something that he or she said before and then twisting that into something different. And that can result in a verbal lashing from the judge in response, or it can also just mean that over time, the judge starts to build this feeling of disdain or annoyance or mistrust against your side. Remember, judges are human too, and they develop a sense over time about the attorneys that are in front of them. Who's professional, who's honest, and who's maybe not so much. And throughout litigation, there are many decisions along the way where the judge has to use his or her discretion. And sometimes if the judge thinks that you have a pattern of being dishonest or unfair, or that you often engage in dirty litigation tactics, that can leave a subtle impression that can make a difference later on down the line when it really matters, when the judge is making one of these discretionary decisions. And so, if I'm reading this correctly, I think that Paul's lawyers might be running the risk of creating a negative impression with the judge at the very least. And that ultimately can, of course, backfire.
Here's where the imbalance comes in. Through the defamation case, Logan potentially gains access to a full stream of information, depositions, internal records, litigation strategy. Meanwhile, the class action plaintiffs are not parties to this case. They do not automatically benefit from the same discovery flow. If one side is able to quietly gather leverage through parallel litigation, that raises fairness questions. That is the type of imbalance the judge appeared concerned about. It was not about CoffeeZilla casually sharing documents. It was about whether the court system could unintentionally tilt in favor of one party over alleged victims in another lawsuit. Another detail that stands out is how Logan's team presented the hearing transcript. They included only a small excerpt. We do not see the full exchange. We do not see how opposing counsel responded in that moment. We do not see whether the judge clarified or limited those comments later in the discussion. That absence matters. If the judge had strongly endorsed Logan's framing of events, that reasoning likely would have appeared clearly in the written order that followed, but it did not. When lawyers selectively quote from transcripts, they take a risk. Judges expect their words to be represented accurately and in full context. Stretching a partial comment into a broader conclusion can weaken credibility. If the court feels its prior statements are being reframed too aggressively, that may not sit well. At this stage, one thing seems obvious. Logan is fighting hard to keep that deposition out of public view. The legal filings, the sealing motions, the procedural battles all circle back to that single point. If he genuinely believes his sworn testimony aligns perfectly with everything he has said publicly, then transparency would not be such a threat. But if there are inconsistencies, the stakes become much higher. Now I want to hear from you. Do you think the court will unseal the deposition, or will Logan's team manage to keep it hidden? Drop your thoughts in the comments. If you've been following this case, make sure you like the video, subscribe to the Beyond Fame channel, and share this breakdown with anyone trying to understand what's really going on. I will see you in the next one.